Ladies and gentlemen, welcome back to the IndieZone. We are now on page 69 of the 157-page transcript from hearing of January 23rd, 2025, regarding the defense's motion to suppress IgG DNA evidence. We are continuing with the direct examination of Rylene Nolan of the Idaho State Police by Ann C. Taylor, counsel for Mr. Koberger. We're at the bottom of page 69, line 25. Question: do you know if that sheet was part, going on to 70, of that preserved for fingerprinting? Again, do you know if that sheath was part of that preserved for fingerprinting? Answer: the swabbing was done first. That's our laboratory standard order of processing. If DNA is needed and fingerprints, they will work together. Essentially, fingerprints will say, we can see some possible ridge details. So if you can avoid this area after DNA says, we want to swab this, and they come to a decision of what would best suit that item of evidence to determine where to swab, so the swabbing takes place first. Question: I think I don't have any more questions right now. Thank you. The court: how long do you think you have? I'm trying to gauge a break here. Mr. Nye, line 15. I'd say 10 minutes. The court: let's take 10 minutes and we'll be back. Recess. Line 19. The court: Mr. Nye, you may inquire. Cross-examination. Line 22 by Mr. Nye. Question: good afternoon. Good morning. I have just a few questions for you today. So, you talked a little bit about policies and procedures in the lab. Do you recall that testimony? We are now at the top of page 71. Answer: yes. Question: and you talked about that there are policies and procedures related specifically to DNA. Is that correct? Answer: correct. As part of those policies and procedures, does the lab need to have a legitimate reason to test DNA? Answer: yes. We only test DNA related to criminal investigations or to death investigations, and it needs to be an item that will answer a probative question in a case. Question: so for example, if someone at the lab wanted to test DNA out of curiosity about medical information, that would not be consistent with that policy. Answer: we don't do curiosity testing, and none of our testing would provide medical information. Question: you also testified that you were involved in, or maybe primarily responsible for, developing the scope of work request for Othram. Is that correct? Line 25. Answer: I was part of that, yes. Now we're going into 72. Question: and what is a scope of work request? Answer: that just goes with, and this was my first one I've done, so I don't have vast experience in this process. But when we're asking to contract with a vendor, just going through and outlining what we expect them to do as part of that. Question: and what do you recall about this request specifically? What were you requesting Othram to do? Answer: specifically, we were requesting them, if necessary, to perform DNA extraction, pulling the DNA out of the cells on an item of evidence if necessary. Our laboratory typically did that. We were requesting them to generate an SMP profile using either SMP array or whole genome test sequencing. We were requesting them to then upload that to all public databases that allow law enforcement samples. We were requesting them to generate a report. We were requesting them to notify us or to complete the lab portion of the work, generation of the profile, within 60 days, I believe. I believe there were also information in there about not publicly giving our case information to the public without our express permission, things of that nature. Question: was there anything in the scope of work, and we're at the bottom of page 72 going into 73, requests related to medical information? Answer: no. Question: so you weren't asking Othram to determine if this DNA, the person whose DNA this was had, for example, cancer? Answer: no. Question. Now, in your position in this case, you testified you didn't actually do any of the testing, but you've read a lot of the reports that were involved. Is that correct? Answer. I've seen a lot of the reports. Correct. Question. And of all the reports you've read, have you seen that kind of information? Answer. No. The testing our laboratory doesn't generate any medical information. Question. And you also talked about, in the scope of work, Othram was required to provide you at least one report. At least one report. Correct is the answer. Question. And did you have a chance to review that? Answer. I have seen that report, yes. Question. Did it contain medical information? Answer. No, it did not. We're at the bottom of page 73. This is the cross-examination of Rylene Nolan by Mr. Nye, counsel for the state of Idaho. Top of page 74. Question. Now you also talked a little bit with Ms. Taylor about an MOU. That was the Memorandum of Understanding, ladies and gentlemen, MOU. Do you remember that discussion? Answer, yes. Question, I just want to be clear. Who were the parties to that MOU? Again, that's Memorandum of Understanding, ladies and gentlemen. This was explored by Ms. Taylor of Ms. Nolin during her direct examination. Again, question, I just want to be clear. Who were the parties to that MOU? Answer, the parts to that MOU specific to this case were the Moscow Police Department, the Latah County Prosecuting Attorney's Office, and Idaho State Police Forensic Services. Question. So Othram was not a party to that MOU. Answer, correct. Question. And the feds was not a party to that MOU. Answer, correct. Question. In another part of your testimony, you spoke with Ms. Taylor about the trash pull. Do you recall that testimony? Answer, yes. Question. And that one of the samples was pulled from the trash. That was a mixed sample. Your lab did not compare. Correct. Is that correct? Answer, correct. Question. And can you explain why you did not compare that? Bottom of page 74 going into 75. Answer. So initially, we did not compare that because it was a mixed profile. We did not know that source of that profile, so it could not be considered a secondary reference. So we deem that to be an evidentiary sample, and we can't make a manual comparison of evidence to evidence, especially when there's a mixture. And if the analyst, again, I was not the analyst, if the analyst did that comparison and determined that unknown male A, ladies and gentlemen, that is A as an apple, this is the sample from the sheath, could have been in that mixture, it would have been inappropriate to compare those two samples together per our analytical methods. Question. And so the decision not to compare that, who made that decision? Answer, that would have been the analyst that worked that case. Question. So you weren't, to your knowledge, no one at the lab was advised, for example, by the lead investigator on this case, which of those items to test? Answer, no. Question. You also gave some testimony about the knife sheath and the swabs on the sheath. Do you recall that? Answer, yes. This is the bottom of 75, going into 76. Question. And I know you don't recall exactly where the knife was swabbed, but we have been talking about policies. Do your policies or best practices suggest where a sheath or an item like that should be swabbed for DNA? Answer, no. It would be impossible for our analytical methods to cover how to swab or where to swab every single item of evidence. We received quite a wide variety of items into the laboratory. So it's the analyst's job as a scientist, as a practitioner in forensic biology screening and DNA analysis, to know what they're targeting. So on this item, I believe there was also blood. So they would have been targeting that separate and then also trying to determine who may have handled that. So they would have specifically honed in on an area that whoever handled it would have had to touch and been touched repeatedly. Line 19, page 76. Question. Why do they hone in on those areas in particular? Answer. because that's the question we are trying to answer. In forensics DNA analysis, the questions we're trying to answer is, can we link assailant to victim, victim to assailant, or one or both to the scene, as in this instance, my bottom page 76 going into 77. So in this instance, my understanding, the sheath was found at the scene. So trying to link the possible perpetrator to the scene. Question line 3. And why in particular do you hone in on the areas where this person may have handled the knife sheath? Because, answer, because looking for, so DNA is found in the cells in our body. And that includes the skin cells that are sloughed off in our hands when items are handled. So looking for any touch DNA is the term that is most often used, or from someone touching or handling an item. Ladies and gentlemen, we now have confirmation from Ms. Nolin of what has been floating about this case, that this is touch DNA. This is what appears to be her testimony. We're going to go back and reread this question and answer. Again, it is line 3. Question, and why in particular do you hone in on the areas where this person may have handled the knife sheath? Answer, because looking for, so DNA is found in the cells in our body, and that includes the skin cells that are sloughed off in our hands when items are handled. So looking for any touch DNA is the term that is most often used, or from someone touching or handling an item. Question. So if I'm understanding correctly, the analyst is swabbing in places that would most likely have been touch DNA. Answer correct. We're on page 77, line 16. Mr. Nye now says, no further questions. Line 17, redirect, says the court. Ms. Taylor, thank you. Your Honor, I would like to start by sharing a computer screen that I have approved with the prosecutor for refreshing her memory. The court, it's just for refreshing. It's not an exhibit. Ms. Taylor, yeah, it is. May I approach? The court, go ahead. Bottom of page 77. What Ms. Taylor is asking for here is permission from the court to approach the witness. She's typically going to be standing several feet, maybe even yards away from the witness stand where Ms. Nolin is. She's asked for permission to approach. The court has given her permission. We are at the top of page 78 of 175, line 1. Have we established she doesn't remember, or are we going to stipulate to it? Ms. Taylor, Your Honor, I can ask the question. The court, we can save time if you're going to stipulate to it. Mr. Nye, yeah, that's totally fine, Your Honor. The court, let's do that. Are you going to share the screen with the court or just her? Ms. Taylor, it's just to refresh her memory, Your Honor. The court, gotcha. Redirect examination by Ms. Taylor, line 17. We were talking at the end of my questions and where Mr. Nye just left off with you about where the sheath would have been swabbed. Reading the email that's been placed in front of you, does that refresh your recollection about what you believe to be the place the sheath was swabbed? 25, bottom of page 79, very much so. Or bottom of page 78, pardon me. Bottom of page 78, line 25, answer by Rylene Nolan, very much so. Now we're going into 79, line 1. Where was it swabbed? Answer. The knife was swabbed the entire, the court. Did you just say the knife was swabbed? The witness, sorry, the sheath. Am I allowed to read it? Line 7 by Ms. Taylor. You're supposed to read it and let it refresh your recollection, and then not read it, but just tell me a summary of where it was. So we're seeing here that she accidentally said one thing. She meant to say sheath, and so she's corrected herself. We are now at line 11. Answer by Ms. Nolin. The entire leather portion of the strap, both top and bottom, and then the underside of the button. I misspoke. She did not swab the top of the button because that was determined to be the most likely place for fingerprints to be found. Question. The underside of the button, was it the part the sticky out part would go into, or the sticky out part, or both? Answer. I can't tell from this. I would have to look at her notes. Question. Okay, good enough. Thank you. A couple of follow-up questions for you. You answered a lot of questions from Mr. Nye about medical information, that your lab does not do testing for medical information. Is that because the bottom of page 79 into 80, you do STR or YSTR testing, not SMP testing? Answer. Correct. Our laboratory performs both STR and YSTRs, and those don't yield medical information. Line 5, question. The MOU you reviewed, and remember the Department of Justice interim policy applied to the circumstances in this case. Do you know who else the interim policy applies to? Answer. Based on what is stated in the interim policy, it applies to public laboratories like ours that receive federal funding in cases where federal funding is being used. So, ladies and gentlemen, I'd like to just point out here, there has been some commentary that what occurred, the horrendous events, the horrible events that happened at 1122 King Road, is a local issue, is something that it should not be commented on or addressed by individuals outside of Idaho. We're learning here. The laboratory receives federal funding. This ISP lab that did the testing receives federal funding. That is federal tax dollars. That comes from a combination of tax dollars paid into the federal government that then goes to finance this ISP lab. So this should, once and for all, throw out any sort of discussion that people throughout the United States should not be interested in, should not comment on, whatever way you feel, whether you feel that Mr. Kohberger, evidence on the record, tends to show the state's case is correct, or if you feel the opposite, that is it tends to show more towards him not being the perpetrator. Now, of course, at every stage, we always have to throw in here that Mr. Kohberger is deemed innocent in a court of law until or unless he either pleads guilty or is adjudicated guilty. So again, we see testimony here that the Idaho State Police Lab receives federal funding. That means from the United States government, and that comes from tax dollars and other sources, from people throughout all 50 states. Line 13, in Mr. Kohberger's case, there was federal funding being used. Answer, to my knowledge, I don't know if we did use federal funding in this case. Question, do you recall talking to me a couple days ago? Answer, yes. Question, and you recall telling me that you did? Answer, I do recall telling you that we had a grant in place, but again, I authorized payment out of the invoice, but which fund the funds come out of, I don't know, and I apologize if I misspoke. The end of page 80 into 81, line 1. Question, and are you aware that the Fed's FIGG unit, I guess, took over and the Feds finished the genetic genealogy after Othram was stopped? Answer, I'm aware we were authorized to turn it over, but as to what happened after that, I don't know. Question, okay, one more question for you. You talked to Mr. Nye a bit about not comparing the sample 95.9.1 to the sheath DNA, and I had asked you a little bit about your policy that allowed you to do the hand search, the manual search on that. Your policy does allow you to do a comparison like it's either excluded or not excluded. Though, is that right? And I'm looking at policy 5.5, I'm looking at policy 4.5.6. Answer, line 15. No, we can report an exclusion. They aren't from the same source, but in order to say they are from the same source, considering they're from completely different areas, no, we would not have to provide a statistic, and we can't do that. Question, but you could have looked at it and said it's not excluded. Answer, that would be an indication that it's possible, and we would have to provide a statistic for that, and we have. So our biology section, you may be looking at our analytical methods biology section, end of page 81 into 82, has their own quality manual that further discusses this. Ms. Taylor, Your Honor, if I can have her shown this document to see if we can refresh her memory. Ladies and gentlemen, I just want to stop here and just interject. This is indicative of what sometimes happens in the examination of a witness. Ms. Taylor a while back said that she had just one more question of Ms. Rylene Nolan here, but based on her answer, this opened the door to perhaps other questioning. So this does go to show, for example, there was some thoughts the day of the 23rd. When will the end of the closed session end so that we can go into the open session? You'll recall on the 23rd, it started out with this closed section from this transcript that we're reading from right now, and then in the afternoon, it went into open session. These are some of the reasons why it may take a little bit longer than the attorney expects, anticipate how long it might take to question a witness, because here she said, Ms. Taylor, a few lines back, I have one more question, but she's going into much more because of the follow-up that's needed based on the answer to the initial question. So again, I want to now go to 82 again, and this is line 3. Ms. Taylor, Your Honor, if I can have her shown this document to see if we can refresh her memory. The court, for the record, identify what you're showing her. Ms. Taylor, what I'm showing her are a couple pages out of the biology manual for the Idaho State Police Forensics Lab that is available online. Question. So, Ms. Nolan, if you're looking at the very bottom one, that's the one I'm having trouble squaring with your testimony, if that refreshes your recollection or helps me understand. Answer. So what this is talking about is it may be beneficial to make a qualitative statement about evidence-to-evidence comparisons. However, there is another section of our biology quality manual that specifically states if it's probative comparison, a statistic must be provided. Line 20. But what this is saying, so for instance, if you're in one room in a scene and there's multiple swabs that are tested, we can say these are consistent or these appear to be from the same unknown individual. Now, if I'm going to say these are from John Doe, I have to provide a statistic for each item, bottom of page 82, and do a comparison of each item, top of page 83. Question, did I hear you say you could compare if they're probative? Answer by Ms. Nolan. If it's, which that wouldn't be, in my mind, a probative comparison, we have multiple items of evidence in the same room in a scene. We can say they appear to be consistent with the same unknown individual. That's not making any statement about who that individual might be. If I'm making a statement about who the source of that, then that is a probative comparison, and I need to provide a statistic. We are on line 13, ladies and gentlemen, with the next question from Ms. Taylor. Before you make the comparison, where maybe you write exclusion. You don't know if it's excluded or included, though. Is that right? Answer, I'm sorry. Could you repeat that? Question, yeah. Let me try and explain what I'm getting at. I'm not understanding why 95.9.1 couldn't have been manually looked at to do a manual comparison to the sheath DNA just to say excluded or not. When male E was compared to multiple items of evidence, and it was excluded, but you don't know that until the comparison. Is that correct? Line 25, answer correct. So you can look at it manually, top of page 84, but if we're now making a probative statement, then we need to provide a statistic. And male E was also a single source, which is different than a mixture of DNA from multiple sources. Question from Ms. Taylor. All right, I don't think I have any other questions. Thank you. Maybe I can take those pages back from you. The court, thank you. You can call your next witness. We will now stop this portion of our review and analysis and comments that we provide pursuant to the First Amendment of the United States Constitution. The next witness will be Matthew Gamet, and we are going to continue on. This is page 84 of 175. Please come back to us when we will, in the next episode of this continuing series of the IndieZone Podcast, continue with the direct examination by Ms. Taylor of Matthew Gamet. Thank you, ladies and gentlemen, for joining us here today.